any one statute or any one code article. Doctrine is going to be a combination of statutes and code articles that, when reviewed together, have an impact on the law. So when they talk about the public records doctrine, if you were to say, well, Ray, what statute is the public records doctrine? If you look down on the bottom of page 36, it starts with Civil Code Article 1839, and there's also revised statute 2721. On the next page, Civil Code Article 3338, and the bottom 3339 and 3340. All of these code articles and statutes working together comprise the public records doctrine. So before we get too far into public records doctrine, when we say that, we're referring to what is on file with the clerk of court. And where is our clerk of court in St. Tammany Parish? Covington. And who is our clerk of court?
Henry.
Melissa Henry. She just.
It's still Melissa right now.
It's still Melissa. Melissa's actually on site.
Yeah,
she's actually physically on site, and she's making decisions. And so far, the one decision I've asked her to make, she's told me no. So she's there, and Melissa's given her the reins to kind of run around. But I know that Melissa and she are still there together right now. So I don't know if her term's officially started, but she is. If she is not now, she is going to be our new clerk of court.
July it starts.
July it starts. So she's our clerk of court. She's in Covington. We have an annex office here in Slidell. Does everybody in Slidell know where the Towers building is? Okay, in that office is an annex office to the clerk of court. If you need to file something with the clerk of court, you don't feel like driving to Covington, you can go to the Towers building and you can file your documentation there, though. But you know what the issue is? You can't get an instrument number in Slidell. So what you're trying to accomplish when you file something, and you're going to learn as we go through this chapter, that the filing of something and getting that document stamped as to when it was recorded and getting a number assigned to its place in line is kind of critical. It's kind of critical to the idea of getting your documents of record. If you were to file something in Slidell, for example, you won't necessarily get an instrument number until all those documents get couriered to Covington and they're assigned instrument numbers there. So I can file something at 8 o'clock in the morning over here, and it may not actually have any legal effect until 3 o'clock in the afternoon, assuming the courier picks everything up at 2. And that may not be a big deal for the average person who's just filing the document, who's not concerned about something time sensitive. But if you are concerned about something time sensitive, you got to get in your car and you got to go to Covington.
Right. Even though if you drop it off at Slidell, it's still going to get recorded as of that date and that time they give you a hand stamp.
They give you a hand stamp?
You get a hand stamp, and then all it's missing is the instrument number. It has the date and time that you dropped it off. And then when it gets to Covington and they record it, they get on that day, then they call you and they give you that number. But it gets recorded the day you drop it off.
Get the recorded the day you drop it off, no question about it. Are you saying it gets recorded as it is timely filed here? Like I get an 8 o'clock instrument number?
Right. Say you have a recorded document, you drop it off at 8:30. They write that time down. When it gets to Covington, that day they work on it, it's going to get recorded, say, today's date as of 8:30, because that's when you dropped it off.
I didn't realize that's the way it worked. They told that is how it works?
Yeah.
Oh, okay.
Now you can get a hand stamp, but they do charge you $2 extra. You have to bring an extra copy and bring it back if you have to have proof.
How do they get your instrument numbers numerically in line?
It's just how it goes, because they go by day.
Okay.
Usually sometimes
So they're not giving instrument numbers in Covington as you're filing these documents?
You only get the instrument number in Covington if they're on that day's work.
Okay.
So say they were working on yesterday's work. They won't give numbers until they get on today's work.
Gotcha.
They finish a day, balance that day, and then start that day's work if they're in it.
Thank you. All right, so we're going to start on the page of 36. We're going to start at the very top. The Public Records Doctrine. The Public Records Doctrine in Louisiana is a set of principles regarding acquiring and improving title to Louisiana immovables, strictly adhered to and founded upon the public policy and the social purposes of assuring stability of land titles and entitling purchasers and others in land transactions to rely upon the public records. The Public Records Doctrine does not create rights in a positive sense, but rather has the negative effect of denying the effectiveness of certain rights unless they are recorded. Now, if history serves, half of you right now are going, what? What exactly does that mean? Because the idea that we can rely upon the absence of something is a difficult concept to wrap your heads around. So one of the things that I think we've maybe fallen short on in the past is that instead of discounting the presence of what is recorded, we try to focus too much on what's not recorded. So let's talk about a practical example of how we can rely upon the absence of something. And let's say I go to my good friend Jessica B, and I say, Jessica, I'm in a financial bind, I need to borrow some money. And you say, well, I'm inclined to loan you some money, but I'm not inclined to loan you some money unless I can collateralize that transaction. So I grant you a second mortgage on my house, okay? And we go to Janet, who's a brand new notary, and she's going to prepare all these documents for us, and you're a savvy negotiator, and you get Janet to agree that instead of going to the courthouse and recording the documents herself and charging you a fee for that service, that she's going to give you the documents and you're going to record the documents yourself. Okay? We're all with me so far in this example? And Jessica, for one reason or another, you just don't go to the courthouse. And that mortgage sits in your file and never gets recorded. And then I go to my good friend Shannon and I say, Shannon, I'm struggling financially. I'd like to borrow some money. And Shannon says, you know, Ray, I'm inclined to loan you some money, but I need it to be secured. I need a collateral position. I say, how about I offer you a mortgage on my house? And she says, okay, sounds good. So we go to Jessica C, and Jessica C drafts the paperwork up because she's a brand new notary. But Jessica C says, no, I record my documents. I don't let my clients take them. They get recorded by me. And she leaves that transaction and she goes to the courthouse and she files them. As people who have a tendency to become overextended do, all of a sudden my loans go into default and everybody's scrambling to recover their collateral. Who's got the best collateral position in this particular circumstance? Everybody's pointing to Shanna. Why are you pointing to Jessica? She was the notary. Right. So everybody's pointing to Shanna. So why does Shanna have the best collateral position? That's right. Does it make a difference that I clearly borrowed the money from her second? No. So it is the absence of Jessica B's mortgage in the public records that allows Shanna to rely upon the fact that a second mortgage on my house, in my example, if I wasn't clear, I have a first mortgage on my house, but it's the absence of Jessica B's mortgage on the property that allows Shanna to have the superior security position. So what if Jessica B, once she realizes that she's not recorded the document, she goes to the Towers building and she files it and she gets a hand stamp on it, and it clearly says it was dated prior to and now it's recorded. How does that affect the transaction? Robin shaking her head no, doesn't affect. You shaking your head no, doesn't affect the transaction. Patty says no. Does anybody say it affects the transaction? No. Nobody says that's right. It doesn't affect the transaction. The subsequent recording, the date on the document, has no impact on the validity of the document whatsoever. It is a recordation of the document that creates the impact on the validity of the document. Does that make sense? Okay, so Shanna has a good security position. She's got the second position. Jessica B does not. Even if you get it recorded, now you're in third position regardless of the date on the document.
I'm screwed.
Chances are neither one of you getting paid. People that loan money in second position rarely if ever recover their money. So yeah, chances are, but Shanna's got a better shot at getting paid than you do, no question about it. So I sometimes lose perceptions of time. I was recently asked by a bank to give a legal opinion on the status of their mortgage as it pertained to a piece of property they had made a loan on. And what this gentleman had done is that he, being relatively savvy as to how title transactions and banks loan money, went to two different banks at the exact same time, made the exact same loan, went to two different, you shaking your head yes, you know this.
Because I had a similar situation.
Went to two different title companies that knew that those title companies didn't communicate with one another or use the same abstractors or title insurance providers or anything along those lines, and made the same exact loan against his house, using his house as collateral in the exact same way. So essentially he represented the two banks that he wanted a first mortgage on his home and managed to get two banks to make him a first mortgage on his home. And like people who have a tendency to become overextended, he subsequently defaulted, and when he defaulted on that loan, both banks went and hired attorneys. Both banks began the foreclosure process, but only one of the banks had a first mortgage on the property. And the bank that was told they didn't wanted a second opinion to that fact. So they asked me if I would take a look at it, and I looked at it, and it was pretty clear that although the documents were dated within a day or so of each other, it was the recordation of the document that was relevant. And the bank that had retained me wanted to argue, we made a loan, it was more money, look at the date on the document. They were trying to bring in all these extraneous factors as to why their document, why their mortgage should have some import in this transaction. But no matter what they said, I said, look at the instrument number, look at the time and the date in which it was filed. You weren't even in the courthouse the same day. Not even the same day, the day after. There is no way this mortgage has any superior positioning over the one that was recorded the day prior. So, from a civil standpoint, they have no recovery. Do they have any recovery at all? No? You don't think they're going to go to the district attorney's office and file it? Right. So I would imagine that after they took my opinion and they weren't real happy about it, my guess is the next thing that they did was they filed a criminal complaint. They also probably filed a claim against their title insurance. Now, we don't talk about title insurance too much in this book. It's not necessarily something that you do in your capacity as a notary, but more often than not, it's a question that will come up in closings. Why am I getting title insurance? Why do I have to have title insurance? And in many cases, the title insurance that you're buying in closing is not for you, it's for the bank. Now, when you're buying a house, maybe it's for you too, but when you're refinancing your house, it's always for the bank. And so the bank is insured against losses related to their inability to recover from their security position. So not only are they going to probably file a criminal complaint, but they're also going to file a claim against their title insurance policy and try to recover some of their losses there as well. Okay, so are we all pretty good on the idea? So if we don't get caught up in the idea we can rely upon the absence of documents, we still have to understand that there is a need to rely upon what is recorded. Obviously, it may not have as much, it may not be as significant as what's not there, but we still rely upon what is there, because it's going to say that in just a moment. On that second sentence in that second paragraph, third persons are not allowed to rely on what is contained in the public records. I'm not sure that statement is 100% accurate. Certainly we can rely upon what's in the public records. But I think what they're saying is that in the negative context, what they're saying is that the absence from public records of those interests are required to be recorded. Okay? So the next sentence says, the Louisiana law of recordation, some principles and some problems. The primary concern of the public records doctrine is the protection of third persons against unrecorded interest. So it's this idea that Shanna is protected, in this example that I gave, from any claim that Jessica B. might have because she failed to get a recorded interest in that property when it was really her obligation to get that document recorded. Okay? All right, the public records doctrine is derived from various enactments meant to affect this public policy. For example, Civil Code Article 1839. A transfer removal property must be made by authentic act or act by under private signature. Nevertheless, an oral transfer is valid between the parties when the property has been actually delivered and the transfer recognizes the transfer when interrogated on oath. An instrument involving immovable property shall have effect against third persons only from the time it is filed for registry in the parish where the property is located. All right, so let's go over this article one more time. A transfer removable property must be made by authentic act. Who in here knows what an authentic act is? What's an authentic act, Shanna? You're cheating, but what's an authentic act?
2 witnesses and a notary.
Two witnesses.
signature.
And the witnesses, can they be the notary?
No.
Can the witnesses be the principals to the act?
No.
All right, so it's got to be 2 completely separate witnesses and the notary. And so what they're saying is here, nevertheless, an oral transfer is valid between the parties when the property has been actually delivered, and the transferor recognizes the transfer when interrogated under oath. In your capacity as a notary, you'll never deal with a transaction like that. So what they're saying is that although it is legally possible to verbally transfer a movable property, it's going to obviously require some type of litigation where an interrogation under oath is going to take place. So an oral transfer where the recipient acknowledges under oath the receipt of the property is also a transfer pursuant to the Civil Code article, but as notaries, we will not participate in something like that. Does that make sense? Okay. An instrument involving immovable property shall have effect against third persons only from the time it is filed for registry in the parish where the property is located. So if the property in the example I was given earlier is in St. Tammany Parish, but Jessica C. takes the documents and she records it in St. Bernard Parish. No? Robin said no?
No, I said, uh-oh. I said,
Oh, Donna says uh-oh. So filing it in St. Bernard Parish has no legal effect because that's not where the property is located. Doesn't make a difference when it's stamped, doesn't make a difference what instrument number it has no correlative effect to St. Tammany Parish because it did not get recorded in the parish where it was supposed to be recorded. And unfortunately, in the title business, that happens sometimes, particularly in the greater metropolitan area where you service a lot of clients in Tangipahoa, Jefferson, St. Bernard. Sometimes you're not paying attention and you'll throw something in a St. Bernard envelope. And you would think the St. Bernard Parish Clerk of Court would call you up and say, hey, you're trying to file this in the wrong place. More often than not, they'll just take your fee, record it, and send it back to you. The Clerk of Court's not really a policing agency. I think as a courtesy, You know, particularly the people we've got relationships with, they would give us a call and say, hey, you guys may have sent something to the wrong place. But for the most part, the clerk's not going to police what you file. You can't count on that step as a checks and balances of what you've done, because a lot of times the clerk will just take your fee, record your document, send it back to you. All right? Revised Statute 92721, filing in the Office of Parish Recorder. Part B, because A has been repealed, says an act of sale of removable property or attachment thereto filed for registry in the Office of the Parish Recorder pursuant to subsection A of this section shall designate the name of the person responsible for all property taxes and assessments and include the address where the property tax and assessment notices are to be mailed. The person responsible for these tax assessments of the immovable being transferred shall provide the above information to the tax assessor for the parish in which the immovable property is located for the purposes of issuing tax and assessment notices. In St. Tammany, if you do not give that information in the act, the assessor will automatically assume it is the address of the buyer. And so if you fail to say, please send all tax notices to this address, our assessor will take the address of the buyer and send tax notices to that address by default. And so I had a client one time who had a piece of property in his corporation's name, and he had the tax bills going to his house. This is a piece of property he had in Jefferson Parish. And he wanted to borrow some money against him. We don't have any mortgage bankers in here, right? Well, if you're a mortgage banker, you don't really want to loan money to businesses. That's not something that you're interested in doing. You like loaning money to individuals. So he had to go to a notary, and he had to transfer the property out of his business name and into his personal name so he'd qualify for a home loan. And in doing so, that notary failed to put, please send all tax notices to this address, and instead just showed his appearance at the property address he was applying for the loan for. So it was the property he was transferring to himself personally at that property's address, not his other home where he lived and resided. This was investment property for him. Subsequent to that transaction, tax bill doesn't show up. He doesn't pay it. Doesn't pay it for 5 years. Someone files suit against him and takes his property away from him. And look, he has some fault there. You have a responsibility of knowing where your tax bills are. But he felt as though the notary was culpable in that because the notary had an obligation pursuant to this statute, 92721, to put the proper address where tax bills were supposed to go. And that notary took it upon herself to just put the property address as the address. So when he and I were talking about it, he had every intentions of trying to recover some of his losses from the notary on a malpractice basis. I didn't take that case. I don't think it's a valid case. But these are the kinds of things, these are the kinds of questions you've got to ask as you're preparing these documents. Hey, pursuant to 2721, where are these tax bills going to go? All right, subpart C says anyone who acquires immovable property in the state, whether by sale, share of sale, giving in payment, or any other manner, which property is subject to a recorded lease agreement that is not divested by the acquisition, shall take the property subject to all provisions of the lease, including any provision for the payment of a commission to a leasing agent or other third party, provided that the lease was recorded prior to the recordation of the document which establishes the rights of the person who acquires the property. Such document shall include, but is not limited to, a mortgage, option to purchase, or other writing. That's a lot, right?
Yes.
All right, so let's talk about that. Let's talk about that example for a second. So, in the context of public records, we have this first in line, first in right theory. In the example we just talked about, Jessica B. failed to get her mortgage recorded in front of Shanna, so she wasn't first in line, or even second in line in the example that I gave. She was behind everyone else for failing to record timely. So what they're saying is that if I've got a piece of property, and let's say, Angela, I'm leasing some property from you, and you've got a mortgage on your property, and my lease doesn't get recorded. So that lease is private. It exists. I pay monthly as I'm supposed to, but this lease is a private document between you and I, and it's not of record anywhere. And then you decide that you're going to sell the property to Rebecca. And Rebecca knows that I'm in the house. She knows that I'm leasing from you, and she's even seen the lease. When she buys the property, if the lease is not recorded, she's not bound to honor it. So the first thing Rebecca could do once she buys the property is put a notice to vacate on my door and evict me. Because I'm now squatting in her property. She buys the property subject to what's in the record. What wasn't in the record is the lease that Angela and I had. Now, if the lease is there and she buys the property, she has to honor the lease. If it's of record at the time of the purchase, her good faith, bad faith, whether she knew about it or didn't know about it, is not relevant to whether or not it's recorded, because the recordation is what creates the right. So if she buys a property subject to the lease, she's got to honor it. And let's say she owes Donna a commission under that lease. She's got to pay that commission. So when you buy that property subject to that lease, you've got to honor all the terms and conditions. Now, when it comes time to renew, she has no obligation to renew with me. She has no obligation to extend. She has no obligation to negotiate with me in any way, shape, or form. Only to the extent of that document. So it says in here, or maybe it didn't say in here, option to purchase. You know what an option to purchase is? An option to purchase is almost exactly like it sounds. It's an agreement where I'm leasing this house from Angel, but she decides that at the end of the lease, I can buy it from her for $100,000. She's gonna give me that deal. If you buy it at the end of the lease, if you want, I'm gonna give you the option to buy the house for $100,000. So an option to purchase is a way to negotiate a fixed price for something now and actually buy it in the future. Maybe buy it, option, it's an option to purchase. So she sells the house to Rebecca, subject to my recorded lease with an option to purchase. At the end of the transaction, I say, Rebecca, I'm gonna exercise my option. You have to sell it to me?
Yes.
You sure do. Because the option was of record, you bought it subject to the transaction. And so if there was an option for me to purchase that property, you gotta honor that option. So you gotta honor any legal right that exists in that document when you buy a piece of property subject to something. How we doing? Okay?
I have a question.
Yes, ma'am.
As a renter,
Mm-hmm.
if you're renting a property, can you find out from the landlord if, that when they're selling, if they have that in there that you're renting from them? So you can't be evicted?
Well, you know how you can stop that? Just take your lease to the courthouse and file it and record it. Yeah, now look, I think in a practical sense, it's gonna be hard to sell your property without somebody walking into your property and seeing it. So when this person's walking through your house, open up your closet doors, you're gonna probably wanna know why they're there. So I think in a practical sense, it's very difficult for a landlord, a lessor, to sell a lessee's property or to sell their property to some third party. But no, you could. You could say, yeah, would you please let me know if you ever have any intentions of selling the property? And I say, sure. And then I don't do it. But you have no legal recourse on that basis. The legal recourse is to take the lease to the courthouse and file it. That's the legal recourse. Now that it's of record, the property's you've got to be notified. You've got to be notified. And any third-party purchaser who buys the property has to know that they're going to be dealing with you at that point in time. So you don't need your landlord to cooperate with you. You've got the ability to control it within yourself. All you have to do is have a copy of the lease. You know how many times I've dealt with lessees who did not have copies of their lease up? It's amazing. And so I'll deal with a lessee, walk into my office, they'll have an issue, and I say, where's your lease? I never got it. What do you mean you never got it? I signed it. I was at their kitchen table. I remember signing it. I don't have it. So it's very hard to give you a consult on what your rights are as a lessee if I can't see your lease. Because sometimes in leases, lessors are pretty savvy, and they will say, this document shall not be recorded. And in the event that it is recorded, the parties to this lease agree that third parties will not be bound by its recordation. And that way, if the lessee runs out and records at the last second, it'll have no legal effect because you agree in the document itself that it'll have no legal effect despite its recordation.
A lot of people do not read the leases. I
Oh,
can tell
yeah.
you that because I write them all the time. They do
A lot of
not
people don't read them. Does that answer your question?
Yeah.
Okay. All right, so Article 3338, instruments creating real rights and immovables, recordation required to affect third persons. Now, that affect third persons is really, really important because, Buffy, if you and I execute a transaction, it is effective as to you and I immediately upon its signing. Okay, so the idea behind it having effect on third persons is that as long as we're legally bound to it, that doesn't mean that anybody else is legally obligated to honor it, address it, or deal with it because it's not recorded anywhere. It's legally effective between us, not legally effective as to third persons. So in that example that we had, I'm the one that's getting kicked out of the property, and Angel, you're the one that had the lease with me, and the moment that the transaction is done, Rebecca comes and evicts me. Guess who I'm suing? I'm suing you, because you promised me a piece of property. The fact that we didn't get it recorded, let's be real clear, the fact that we didn't get it recorded is what gives Rebecca the right to evict me. The fact that it wasn't recorded doesn't nullify the lease. It doesn't make it less effective between Angel and I. She promised me a place to live for 12 months. If I paid her a certain amount of rent, and she's no longer able to honor that obligation because she sold the property to Rebecca, who refused to honor it. So I'm not necessarily out in the cold in that situation. I have remedies, but unfortunately one of them is not to stay in the house. I have remedies for breach against my lessor. Okay. So the rights and obligations established or created by the following written instruments are without effect as to third persons unless the instrument is registered by recording in the appropriate mortgage or conveyance records pursuant to the provisions of title. Number one, an instrument that transfers an immovable or establishes a real right in or over an immovable. Well, the first part of number one is a sale. The second part of number one is a lease. So that a real right over an immovable is a lease, and a conveyance is going to be number one, or the first part of number one. The lease of an immovable, an option or right of first refusal, or a contract to buy, sell, or lease an immovable, or to establish a real right in or over an immovable. And number four, an instrument that modifies, terminates, or transfers the rights created or evidenced by the instrument described in subparagraphs 1 through 3 of this article. Okay, so we all know what an option is. What's a right of first refusal? Anybody tell me what a right of...
When you have the option to buy the house that you're,
Wouldn't that be the option?
right.
So what's a right of first refusal? Is it the exact same thing?
No, you get to say you don't want it.
That's right.
They have to present it to you.
That's right. So the option that we talked about just a moment ago says at the end of the transaction I have the option to buy it. It's my option to exercise when I want to exercise it, or within the time frame we've negotiated for. If I negotiate for a right of first refusal, that means if I am negotiating with Patty in this particular scenario, Patty had negotiated for right of first refusal, and Shanna goes to her and wants to buy this piece of property from her, she's got to call me up and she says, Ray, I have a valid offer from a third party. It's an arm's length transaction, and I intend to accept it. Are you going to exercise your right of first refusal? Are you going to buy the property on the same terms and conditions that Shanna's going to buy it from me for? If not, I'm going to sell it to Shanna. So a right of first refusal doesn't give me a set price and a set time frame in which to buy it. It gives me an opportunity to match someone else's offer to buy it before I let them buy it. And you see rights of first refusal, I don't see them in residential transactions. I see options in residential transactions, but I see rights of first refusal in commercial transactions. Do y'all see them anywhere else?
I just wrote one today.
On a residential property? What was the circumstances?
Okay, I'm trying to make it short. Was in contract to purchase, and it was a lease purchase,
Okay.
which I hate them. But the seller said, yes, we'll do it. And one thing led to another. The girl could not qualify for the loan because a divorce could not be finalized because the husband had done an illegal, adding her to a business illegally without her knowledge. So that all has to be cleared up. Now, she's already been in the house, and so the owner says, this is her choice. She can stay in, these are how she can stay in, but I will give her right to first refusal.
Gotcha.
Because we're putting it back on the market to sell. And we're letting her lease it month to month. But she does get the right of first refusal if she can qualify.
If she can
for the loan.
qualify.
And we
Okay.
did put that caveat. But I had to create that document because I looked all through our.
Yeah, I just don't think that you use them, I don't know that they're
No.
really commonplace in
No.
residential.
It's the first thing in 11 years I've ever had to do.
You'll sometimes see these in community property partitions. You know what a community property partition is? Husband and wife get divorced and they gotta split up their property and there's always a family home involved. Sometimes the spouse who has to leave the house will negotiate for a right of first refusal. You know, generally that spouse is bought out by the spouse that stays in the house. That's typically the way that works. And then for whatever reason, sentimental reasons, they want to keep the kids in the same school districts, whatever the case may be, they'll write into their partition in the event that my wife doesn't want to be in this house anymore. If she takes a bona fide offer from a third party, I've got the right to match it to buy the house back, to keep the kids in school and that kind of stuff. So you'll sometimes see them in community property partitions, but outside of that, I just don't see them in residential transactions. Okay?
I did one and put those in record, those rights and those.
If they're not in the record, then they're
I'm just
not.
saying, you have to take those in those files.
Absolutely.
Once they're signed or refused or.
That's right.
Okay.
If I don't get that right of first refusal into the public records, then there's no one bound to honor it. And so in that situation where I have a right to buy your house on a first refusal and we don't get it to the public records and someone comes along and makes you a bona fide offer and you take it, there's nothing I can do except sue you for breach of contract. The person that's bought the property bought it in good faith and not subject to our unrecorded instrument. That's the absence, that's the being able to rely upon the absence of something. Clearly, we have an agreement, but because we failed to record it, no one's bound to honor it. Somebody else was about to ask a question. Was it you,
I
Patty?
was just gonna say, a family member bought 10 acres of property,
Mm-hmm.
and the seller had an additional 10 acres adjacent to it.
Okay.
And so he asked for
There you
right
go.
of first refusal.
I kind of think of that as a commercial transaction. I imagine they want 20 acres for development purposes, right?
No, it's all residential.
Oh, all residential? So what he wanted to do is he wanted to write a first refusal so he could control who his neighbor was gonna be. Okay, I like that. What other examples do they give in here? Contract to buy or sell. Okay. Matters not of record, Article 3339, bottom of page 37, a matter of capacity or authority, the occurrence of a suspensive or resolutory condition, the exercise of an option or right of first refusal, a tacit acceptance, a termination of rights that depends upon the occurrence of a condition, and a similar matter pertaining to rights and obligations evidenced by a recorded instrument are effective as to third persons, although not evidenced of record. Let's talk about these things first, and let's talk about how this applies to what we're talking about. So when they say a matter of capacity or authority, does anybody have any idea what they're referring to? Anybody affiliated with any businesses in here? No? Nobody's affiliated with the Buffy? What's your? Oh, you're affiliated with the business. So if the business owns immovable property, and we go to closing, and Jessica C shows up on behalf of your company, and there's nothing in the public records that indicates that she has the right to act on behalf of your company. So that would be an example of a lack of capacity. She might very well have the right to act on behalf of your company, but unless there's something in the public records that indicates that there's going to be some question as to the validity of that act. So when they're talking about capacity and authority, they're talking about a certificate of authority or a resolution, something that says this person has the right to act on behalf of this business. Okay? A suspensive or resolutory condition. These are kind of tricky, suspensive and resolutory conditions. So let's talk about the suspensive condition. Let's just say, for the sake of argument, Janet, you've got a piece of property that you want to sell, but for one reason or another, we can't get to that property. There's a public road that's been allocated by the parish to access your property, but for one reason or another, it's just never been developed. Okay, y'all with me so far? Mm-hmm. And I come to you and I say, Janet, I'm going to buy that property from you for X number of dollars when the parish puts a road in that will allow me to access it. Okay? And you say, okay, Ray, let's put this in writing. Let's get this transaction in writing. I'm going to sell it to you for X number of dollars as soon as the parish puts a road in. Mm-hmm. Let's say 10 years goes by and the parish has not put the road in. Okay? Do I have an obligation to buy that property? That's right, because it was suspended until a condition was met. Let's say 10 years and a day go by and the parish puts a road in. Mm-hmm. Do I have an obligation to buy that property?
Yeah.
Yes, I do.
Yes.
Because the event that triggered the transaction was suspended until the road was put in. So the moment the road was put in, I now have an obligation to purchase the property. We all okay with that?
Mm-hmm. Can you put a limitation on that?
Yeah, you certainly can put a limitation on that.
Okay.
If you don't, I think it's going to be open-ended. We might have a prescription argument somewhere else in the book, but we could certainly say if they put a road in within the next 3 years, we could do that. And if 3 years comes and goes and they never put the road in, I have no obligation. 3 years and 6 months goes and they put the road in, if we had a stipulation it was just for 3 years, I have no obligation. Cody, you had a question?
What if one of the parties died?
Well, more often than not, these kinds of agreements are going to be binding on the heirs, successors, and/or assigns. You're going to see that language in almost every act that you look at and almost every act that you draft. So if she enters into an agreement with me and we have it in writing and she were to pass away, her children will be obligated to honor that agreement. My children will be obligated to honor that agreement too. Okay? So binding on the party's heirs, H-E-I-R-S, successors, and/or assigns is typically what you see.
So do the heirs have to sign that?
Nope, they don't have to sign it.
So you could say that and your children not even know that they...
Yeah, now in the example that I'm giving, it's more of an issue for Janet's children than it is for my children. Because if my children don't want to perform, you'll have a hard time holding them accountable to it.
Okay.
But you're the one trying to sell something, the condition's being created, and I want it. And if I'm still alive and you pass away and I can prove that the condition's been met, I can hold your children accountable to it.
But
Okay.
then again, it is a problem if your kids do want it and her kids don't want to sell it.
Right.
Yeah, that's a problem. Thank goodness I went to law school. So it's going to be a problem. It's going to be a litigious problem, but there's still a valid contract there. So, when somebody doesn't want to perform in a contract, that doesn't necessarily mean that the contract becomes null and void because they don't want to perform.
I just don't understand why you wouldn't, when you're putting your heirs in that type of position, why you wouldn't get some type of formal document or for them to sign too.
What if they're 16? Yeah, they're not illegal. They don't have the capacity to execute a document. It's and keep in mind, it's going to be binding on her heirs. At the time she made this deal with me, this was her property, not her
Right.
children's property.
Right.
Okay, and so at the point in time that we choose to exercise the transaction because the suspensive condition's been met, you passed away in this example. I'm sorry, you passed away in this example. But what your children have inherited are all of your obligations. They've inherited all of her assets and all of her obligations. One of her obligations was to sell me a piece of property if a road was ever put in. The children have to honor it. And you don't need their permission to do it. Now, the children can breach the agreement, and it's going to potentially become litigious if that's the circumstances. But if they're going to honor the agreement and they have an obligation to, then they're going to sell me that property. So let's not get too far off track, but that's a suspensive condition. So we all understand that the suspensive condition is that something that may or may not be met at the future, when it's met, the parties are now obligated to act. So here's a resolutory condition. A resolutory condition is the transaction happens now, and the undoing of the transaction happens upon some potential future event. Okay, so in the example with Janet, I'm going to buy the property at some point in the future if they ever put the road in. So the transaction is suspended until the event. Here's an example of resolutory condition. My wife and I get divorced, and I give her the house as part of the divorce. She can't qualify for a loan to refinance the home loan, so she says, I will take over the house payments. Okay, so I'm take title now, and I'll begin making the house payments now. The resolutory condition is that if she stops making the house payments, I get my half of the house back. So the idea is that we're going to do the transaction now, but in the future event where you fail to perform the obligation you promised to make, I get my property back. So the resolutory condition undoes a transaction now. A suspensive condition suspends the transaction until the event. What do you think, Dad? You're not even paying attention. All right, so it is confusing.
The example is really good because you'll relate to like a military clause in a lease. That's a little easier to understand. It's a good example.
Military and other persons who are subject to a work-related transfer require a clause in their lease that allows them to be released from their obligation in the event of a transfer. That clause is a resolutory condition. I agree with that. Because they're leasing the property now, the transfer may or may not ever come. But if it comes, the transaction gets undone. That's a resolutory condition. Might use that one in the future, as opposed to my divorce one.
Do you like that?
Yeah, I did like that.
That's mine.
Yeah, I like it. I like it. I thought my divorce one was pretty good too until Patty said no, but all right. All right, so the exercise of an option or right of first refusal, a tacit acceptance, So this is a tacit acceptance. Let's just say for the sake of discussion, do you have one for tacit acceptance too?
No, but I did have a good one for suspense.
All right, so a tacit acceptance is that a transaction by which one of the parties appears to have accepted it by all of their actions, even though they may not have actually accepted it in writing. So Jessica, if I agree to sell you my watch, and I say, listen, I'll sell you my watch for $500. And you don't say okay, but you take my watch from me and you put it on and you leave. Do we have a deal? Can I assume based upon the fact that you took my watch and you put it on and you walked out the room that we had a deal? Because the delivery of the $500 is something that can come subsequent. The actual delivery of the cash is not what perfects the transaction, it's just part of the transaction. So I would make the argument, when you didn't pay me the $500, I would make the argument that you accepted it, even though you said, well, no, I never said I wanted the watch, but your actions demonstrated that you did.
We didn't sign anything.
But I know we didn't sign anything, but tacit acceptance doesn't require a signature. The idea behind tacit acceptance is that your actions demonstrated you've accepted the deal, even though you may not have said anything or you may not have written anything to indicate so. And people, tacit, T-A-C-I-T, it's on the page 37, it's the second sentence of Article 3339. These are matters not of record, is what we're talking about. So, I see what you're saying. You're saying, hey, look, I'm not legally bound to this transaction. That would be your defense to my argument that you owe me $500 for the watch. That would be your defense. I didn't say I was taking it, and I didn't put anything in writing that says I was taking it. And my argument is going to be that all of your actions indicated that you took the deal. By the way, where's my watch? Okay? All right, so that's tacit acceptance. All right, so a termination of rights that depends upon the occurrence of a condition in a similar manner pertaining to rights and obligations evidenced by a recorded instrument are effective as the third persons, although not evidenced of record. So now that we've kind of covered what these things are, let's talk about how they're not of record. So we talked about the suspensive condition. Our agreement, Janet, our agreement to buy your property when that road gets put in, that agreement to be effective against third persons has to be recorded.
Right.
What's not of record is whether or not the road gets put in. That's what third parties have to worry about. So when you come behind a document and you see that there's a suspensive condition regarding this purchase, you may or may not know if the suspensive condition has been met because you may or may not know about the status of the road. So the status of the road is a matter not of record, but it's obviously binding. It obviously has an impact on our transaction. My wife may have missed that house payment, and therefore I have the opportunity to go get my half of the house back. The opportunity to go recover my half of the house is in the public record in our community property partition, but whether or not she's missed the payment is not in the public record. So that's what they're talking about. So the not paying of the house note and the resolutory condition section, that is something not of record that clearly has an impact on third parties. Okay? In a situation where I am going to verbally lease my house, okay, and I lease it to Robin and Robin moves in, but we don't have a written lease, her physical possession of the property is going to be argued as being tacit acceptance. So there are certain actions that could have an impact on immovable property. So are y'all with me on that? Okay, so that's the idea. The idea is that there are things that could have an impact on other documents that are recorded. You know about the recorded documents, but you may not know about the events that trigger them. And that's what 3339 is all about. Okay? 3340, the effective recording of the documents. If the law or a recorded instrument expressly makes the recordation of an act or instrument a condition to the creation, extinction, or modification of rights or obligations, such act or instrument is not effective as to third persons until it is recorded. I think we've been kind of hammering that point all night. All right, top of page 38, the recordation of a document other than an instrument described in Article 3338 that is required by law to be registered, filed, or otherwise recorded with the clerk of court or recorder of conveyances or mortgages, or in the conveyance or mortgage record shall only have the effect provided for by such law. People try to take things to the clerk of court and record them because they feel like recording something gives it legal effect. They think getting it notarized gives it legal effect. I can't tell you how many people have stumbled in here with documents that make no sense whatsoever, wanting to pay us a fee to notarize a document because they think the moment that I notarize the document becomes valid. Well, they feel the same way about the recordation of that document. If I take it to the clerk of court and I file it, it's obviously legal now. The clerk of court took it, and that's neither my job as a notary or the clerk's job as the clerk to police or to regulate or to validate the legal efficacy of documents. I think this is where I tell the story about my guy with the boat. I had a client of mine who came into the office one day who wanted me to notarize a bill of sale. And they'd already been to two other notaries, and both notaries had turned them down, told them they wouldn't do it. This was the issue. It really wasn't a boat. It was kind of like a camper that this person had put on the seller's property. And it was something that he slept in when he hunted and fished on this guy's property. And he wasn't paying his hunting and fishing lease. And so the owner of the property took the camper and was selling the camper to a third party to recover the money that he was owed underneath the hunting and fishing lease. Does that all make sense? Mm-hmm. It's also illegal. You can't do it that way. We're not a self-help state. We don't have the right to physically recover property and sell it without a court order or without sheriff's seizure. So you just can't go taking someone's collateral and liquidating it. The buyer knew exactly what was going on. He knew that the seller didn't own the camper, but he wanted to buy it anyway. And he was looking for a notary to notarize a document because he thought the moment a notary put the seal on the document that it would be okay for him to purchase this stolen camper. And so I told him, as he's explaining to me what he wants to do, I told him, I said, listen, because you're a client of mine, I'll notarize it. I'm gonna put a big old disclaimer in it that I'm not responsible for the validity of this act. I'm not responsible for the title to this camper. And I'm telling you right now, you're wasting your time. Because if you produce this notarized bill of sale of something that you know is stolen, that does not change your status as a purchaser from a bad faith to a good faith purchaser. You're still a bad faith purchaser of a stolen item. I don't care how many times the document gets notarized. I don't care where you take it to get recorded. He ultimately bought it. He bought it anyway because it was apparently a crappy camper and it wasn't a whole lot of money, and he just couldn't imagine the guy that owned it, given how much he owed the lessor, would ever come back and get it. So he made a business decision to buy it anyway, but that doesn't make it right. That just means he rationalized why he was buying something stolen from someone. Okay? So, the effects of recordation, part 1, it does not create a presumption the instrument is valid or genuine. It does not create a presumption as to capacity or status of the parties. It has no effect unless the law expressly provides for its recordation. So when it says it does not create a presumption as to the capacity or status of the parties, so if Jessica C. shows up on behalf of Buffy's company, and Buffy's never given Jessica C. the authorization to represent her company in these transactions, the mere recordation of the act with Jessica signing on behalf of Buffy's company does not make it a valid transaction. If Jessica lacks the capacity to represent Buffy's company, that transaction is not valid, and the recordation of it does not make it valid. That's what part 2 is saying. And it has no effect unless the law expressly provides for its recordation. We do affidavits of owner occupancy in real estate closes all the time, where we have the client sign an affidavit acknowledging that the house that they're buying is going to be their primary residence as support of the fact that the bank has given them an owner-occupied interest rate, which are always better than non-owner-occupied interest rates. So if I took that affidavit of owner occupancy down to the courthouse and filed it, there'd be no legal effect in doing so because there's no requirement that an affidavit of that nature be recorded to start with. So just recording something does not give it legal effect. Recording something only creates legal effect when there's a reason to record it, when there's a statute or a court article that says it needs to be recorded. Make sense? All right. 3343, third person defined. It says a third person is a person who is not a party to or personally bound by an instrument. A witness to an act is a third person with respect to it. A person who by contract assumes an obligation or is bound by contract to recognize a right is not a third person with respect to obligation or right to the instrument creating or establishing it. All right, so we're going to talk about, when we get to marital regimes, we're going to talk about community property and separate property. But as a rule, everyone knows that Louisiana is a community property state. Is that a fair statement?
Yeah.
We can buy property in Louisiana as our separate property despite being married. Okay, so I can go to a real estate transaction closing and I can buy a piece of property and I can make a declaration in the act that the property that I'm buying is in fact my separate property despite the fact that I'm married in a community property regime. There's this. Go
If
ahead.
something happens to you, does your wife get that property even though you bought it separately?
Do I have a will?
No.
No. Then no.
So who gets the property?
My kids,
What if you don't have any kids?
my siblings, and my parents.
Oh, okay.
We'll talk about that. That's actually specifically covered in the testament section of this book. We'll talk about all that kind of stuff. So what happens is that there's a statute that says that if my wife appears in the act and she concurs with my statement that it's my separate property, then she's forever barred from challenging the validity of the statement down the road. The statute also says that if my wife does not appear in the act and does not concur in the statement, that she has the right to challenge the validity of the statement to go back and get her half interest in the property. So if I have taken the property as my separate property because I need to finagle my financing, or for whatever reason, and it's just not a true statement, the money that I put down towards the purchase is community income or community property, the payments that I make on the loan or from community income, it's clearly a false statement. Third parties are allowed to honor it, but my wife could easily come back in and prove that the whole thing is bogus and get her half of the property. All right, so the reason I'm telling you this is because of the second part of 3343. A witness to an act is a third person with respect to it. So in a closing, not one that I did, but in a closing that happened one time, husband came in, made a declaration, it was his separate property, his wife was sitting there right there next to him, and she was one of the witnesses to the act. So Shannon gave us an example a moment ago. She said an authentic act is an act that's done before a notary and two witnesses, where the witnesses are neither the principal nor the notary, okay? So, husband and wife, husband buys a piece of property, wife is a witness to the transaction. They get divorced, she wants half that property. She says the whole thing was bogus, the whole thing was a scam. It was so he could finagle a better interest rate with his lender if she wasn't included in the transaction because she had bad credit or something like that. But that makes no difference. The down payment was community property, the payments were made with community income. I want half that property. To my knowledge, that part of 3343 prevented her from doing so, because she was deemed to be a third party to the act. Even though she didn't specifically appear and concur that the statement was true, she appeared in the act itself and was deemed to be a third party. So she was prevented from going after the property as a result,
Because she signed
Because she
as
was
a
aware.
witness.
She was
because she
alive.
signed as a witness. Everybody agrees that that's the appropriate way to interpret that? Yeah, that's the way St. Tammany interpreted it, at least. All right, so 3351, ancient documents, presumptions. An instrument that has been recorded for at least 10 years is presumed to have been signed by all persons whose purported signatures are affixed thereto, and if a judgment that it was rendered by a court of competent jurisdiction, the recording shall have effect from the time when the act is deposited in the proper office and endorsed by the proper officer. So besides an instrument being recorded for at least 10 years is presumed to have been signed by all the persons, it's also been presumed that all the persons had the proper capacity. So I've used this example where Jessica is acting on behalf of Buffy's company without permission. If she executes a transaction where she's acting on behalf of Buffy's company and 10 years go by and Buffy never challenges the validity of the act, she's presumed to have had the capacity because no one bothered to challenge within that 10-year window. Okay. That 10-year time frame as we go throughout the book will pop up. Lots of things are relevant in 10-year increments under Louisiana law. Okay. Parish, all right, we okay so far with those court articles? All right, parish recorders. Notaries historically kept and preserved in their offices and under their custody the originals of all authentic acts executed before them. Before any law on the subject was enacted, the governor, in adherence to the duty incumbent upon him to care for and preserve the public property and records when a notary died or resigned, appointed another notary and gave him charge of the vacant office in the commission, and it necessarily followed of the record. So prior to there being a centralized clerk of court, you had a responsibility to maintain all your documents. Do you have any idea how much office space you would need to do something like that? So the parish recorder is a fantastic outlet for us who needs to get rid of our paper. And so we can take everything to the clerk of court and we can file it and we can kind of minimize the stuff in our office as a result. Prior to the parish recorder system, when a notary died, the governor came in and appointed another notary responsible for taking over all their papers. In a lot of civil law jurisdictions, none of which really are in the United States, but mostly in Latin American countries, those notaries down there still maintain all of their private documents. They still hold all their private documents. We had a lady, a client of ours, who owned a piece of property in Lakeview. Remember what country she was from?
Isn't that Guatemala?
Guatemala, something like that. So she was a resident of Guatemala, had a Spanish will, and she died a resident of Guatemala. She just happened to have a house in Lakeview. It was like her second home. And so she died. They probate her succession in Guatemala. They got a judgment ordering the property to her children in Guatemala. Her children come to Louisiana with this Spanish judgment, and they want to try to get the property in Lakeshore put into their name so they can sell it. And it seemed like, with a little bit of administrative effort, we'd be able to get that done. We needed a certified true copy of the last will and testament. We needed it translated into English so we'd be able to read it. We needed a certified translation. And so none of us in the office speak Spanish. So we're trying to find a clerk of court in this little Guatemalan town that she died in. And we call the government offices, and once you get past say habla English, if you got to know, you're like, click, I better call back later. So we're struggling to find anybody. Finally, there's an attorney here in town. If you drive down Pontchartrain Drive, there's an attorney named Ray Murray. He actually has Se Habla Espanol on the sign out front. Ray and I went to law school together, so he eventually came down here and helped us out. And we finally came to the conclusion that there was no clerk of court. That the particular town that she lived in doesn't have a parish recorder. They don't have a centralized recordation base. That we had to go back to the notary who actually had the will. And we had to get a certified true copy from him. And so we find this notary, fortunately he speaks English, and we tell him we need a certified, we need the original will is what we tell him. We need the original will. because pursuant to Louisiana statutes, in order for me to probate a succession, I need the original will or a clerk certified true copy of the will. Without a parish recorder, I can't imagine I can get that. So we said, would you send us the original will? He said, absolutely not. I'm in charge of my documents. They do not leave my office under any circumstances. And I said, well, we can't get a clerk certified true copy of the will because you don't have that kind of a system there. What are we going to do? He says, I'll send you a translated true copy of the testament and you'll just have to probate it. Well, fortunately, this was not the first time Orleans Parish had dealt with anything like this, and we were able to get that document through, and we were able to probate the estate as a result. But we really felt dumb trying to find a clerk of court in Guatemala when they just didn't have one. So not all civil law jurisdictions have parish recorders. I think we're very fortunate here to have one, and I would imagine that the governor of this Guatemalan town, if the notary that we were dealing with were to pass away, would still, just like we used to in Louisiana, appoint someone else to take over his files, so that all those original documents were maintained in some individual's database. Okay? Act number 42 of 1890 made this custom a legal duty for notaries located in Orleans Parish and required them to have each year's acts bound in one volume with complete indexes attached to each volume. The registry of such acts does not appear to have been required until the year 1827, when the legislature created the office of the registrar of the conveyances in New Orleans. All right, so according to Act 1810, no notarial act concerning immovable property had effect against third persons until it was recorded in the office of the judge of the parish where such immovable property is situated. The clerk of each parish court was eventually substituted as the recorder in place of the district judge. The clerks of the district courts are parish registrars of conveyances and recorders of mortgages and notary publics ex officio, revised statute 13751. When we do work in Orleans Parish, we still see references to the district judges who at one time were holding the documents. Orleans Parish is such an old, established area, and there will be occasions for us to have to go back into the chain of title, or the reference to the district judge just happens to kind of been promulgated through the chain of title, but we'll see where the district judge was named and was the holder of either documents related to the closing or maps associated with the subdivisions, and they're not there anymore, but the description of the judge holding those maps or holding those documents still is. It's kind of neat. All right, so Civil Code Article 3346, place of recordation, duty of the recorder, an instrument creating, establishing, or relating to a mortgage or privilege over an immovable, or the pledge of the lessor's rights in the lease of an immovable and its rents, recording the mortgage records of the parish in which the immovable is located. All other instruments are recorded in the conveyance records of that parish. So there are two sets of books. There's actually three, but there's two primary sets of books in the clerk of court's records. You're going to correct me if there's more than three, Shanna? Just three. It's the conveyance, it's the mortgage, and the miscellaneous. Okay. So there's two primary sets of books in the clerk's records: the conveyance and the mortgage books. And it's very important that you know what books to record your documents in. Conveyances, quitclaim deeds, cash sales, credit sales clearly go into the conveyances because they're a conveyance of interest in the property. But credit sales are also security instruments. They actually act as two different things. They act as a conveyance and a method of collateralizing the transaction for the seller. So those go in both books. Whereas a traditional transaction is done where you buy a house and you borrow money from a third party, there's going to be a conveyance and a subsequent mortgage. The conveyance goes in the conveyance records and the mortgage goes in the mortgage records. So recording a mortgage in the conveyance records or recording some type of an obligation in the conveyance records creates a real quandary, because it's there, but it doesn't have any, its effect is questioned because it's not in the right place. And we just dealt with that, where someone actually did an act of sale and for one reason or another purposely recorded the mortgage or recorded the note.
Recorded the note behind the credit sale, but only recorded it in conveyance.
Only recorded in conveyance. And we had an obligation to get that item canceled so we could create clear title for the new buyer. And we struggled to get it done because the item was not properly recorded in the mortgage records where it could be canceled. It was recorded in the conveyance records. And so instead of filing the cancellation, we actually ended up getting an affidavit from the seller, or from the seller who was also the creditor now, saying that the document had been, that the obligation had been satisfied, there was no outstanding balance, and we just put the affidavit into the conveyance records so that someone would see the offset to it, but just wasn't handled in the right way. So, in your capacity as a notary, if you're going to be recording documents on behalf of your clients, it's paramount that you know where things are to be recorded, because not getting them in the right place could have an impact on the validity of the document. So the conveyance records is where the conveyances go. The mortgage records are where your mortgages, your liens, your judgments, and things like that go. The miscellaneous records are where the certificates of authority and the powers of attorney and things that are related to real estate transaction but are not necessarily paramount to real estate transactions go. Those are the three places. An instrument creating, I know that I'm reading this again, page 39, an instrument creating, establishing, or relating to a mortgage or privilege recorded in the mortgage records of the parish in which the immobile is located. You know, there are some parts of Orleans Parish where the houses that you do business on are in Orleans Parish and Jefferson Parish. There are parts of Lakeview where the front yards are Orleans and the backyards are Jefferson Parish. Which parish do you, what's that? Along the canal. So which parish, Angel, do you think you record documents in when it happens to be in both parishes? You pick the front yard or the backyard? The front yard. Anybody agree with Angel on that? The front yard? Jessica, you shaking your head yes?
Yeah.
I think you record them in both parishes. You got to record them in both parishes because you have an obligation pursuant to this code article to get the documents recorded in the property parish where the property is located. If I got the front yard in Orleans and I got the backyard in Jefferson, I better get that document recorded in both parishes if I want to have an impact on both pieces of property. Now, if I want to have an impact on both halves of this piece of property, because it's one lot, it's just in two different parishes. People that live on that canal, they hate doing real estate transactions because everything costs twice as much.
Right,
You got to do everything twice. They
Taxes.
hate it. They hate it. So that's what happens. If you've got a property in multiple parishes, now that's an example of a residential lot, but you actually see it more often than not. There will be big tracts of land that will just happen across. They'll happen across parish lines. I have a client of mine that's got some hunting land that crosses Mississippi lines. It's part in Louisiana and part in Mississippi. Now, fortunately for him, he owns it free and clear, so he's only got a conveyance out there. But if he wanted to borrow money against his property, he'd probably have to go to two different banks, or one bank that did business in both states, and record mortgages and different county records and different parish records. It would be a nightmare. So if your property breaches parish lines, or if your property breaches state lines, if you want your documents to have legal effect, you better get it recorded everywhere that property is located. Otherwise, if it's not recorded there, you don't have the effect that 3346 is telling you that you need. 3347, the effect of recordation arises when the instrument is filed with the recorder and is unaffected by subsequent errors or omissions of the recorder. An instrument is filed with the recorder when he accepts it for recordation in his office. 3348, upon acceptance of an instrument, the recorder shall immediately write upon or stamp it with the date and time. It is filed and registry number assigned to it. That's what Shannon was talking about earlier. Revised Statute 13103, the recorder upon proper request shall issue to any person a copy of the recorded instrument and certify upon it or in a separate certificate attached to it that is a true and correct copy of the instrument, the time and the date the instrument was recorded, and the registration number or of the place in the records where it may be found. You need certified true copies when you're doing business between parishes. So if I'm doing business with a client who was a resident and domiciliary of Orleans Parish and they pass away and they've got property in St. Bernard Parish, they got property in Jefferson Parish, and they got property in St. Tammany Parish, and I need to get the judgment of possession from their succession recorded in all these parishes because I want the property to be properly inherited by the people in all the parishes where the property is located. The clerks of court in those respective parishes are not going to take a photocopy of that document. They're going to want a clerk certified true copy of that judgment of possession in order to be able to take it and accept it into their records. So you typically see, now you'll see it in other circumstances. I'm giving you an example where you see it relatively commonly. You're going to see it where you're doing business in one district court for one thing, but you've got actually business in multiple parishes with those documents. A copy of a recorded instrument certified by the recorder is entitled to the same faith and credit as a recorded instrument. It may be recorded in the mortgage or conveyance records of the parish for the same effect as if it were the recorded instrument. Subpart C says certification by a recorder of a copy of an instrument that is not an authentic form or duly authenticated does not dispense with the necessity of proving the signatures of the parties. All right, revised statute 92758. When the original title or record is no longer in being, a copy is good proof and supplies the want of the original when it is certified as being conformable to the record, but by the notary who has received it, or by one of his successors, or by any other public officer with whom the record was deposited and who had authority to give certified copies of it, provided the loss of the original be previously proved. They're talking about like a lost note affidavit?
That's what it says.
Okay, so We will typically notarize promissory notes in conjunction with real estate transactions, where a person is borrowing money to buy a house or borrowing money to refinance their house. We'll notarize the promissory note, we'll notarize the mortgage. The promissory note, the original promissory note will be sent to the lender and will be held by the lender, and the original mortgage will be brought to the clerk of court and recorded into the public records. And if that person defaults on that loan, then that bank will take that original promissory note to an attorney, and they will retain that attorney to begin a foreclosure proceeding on the house. More often than not, the big banks lose those notes. It's a phenomenon to me how often the banks can't put their hands on the original notes. And they will ask us to certify a copy of the promissory note, because they'll have the copy somewhere stored in their computer, as being an original copy of the note that we executed, because they can't move forward without something tangible indicating that the borrower owed the bank some money. So that's an example in your capacity as a notary where you could be called upon to certify a true copy of a lost document. A lost promissory note associated with a real estate transaction is an example.
And we get $75 for that.
We get $75. Now that was something that they started offering us to get us to cooperate, right?
And now I just charge everybody that does it.
Oh, okay. Yeah, what happened was the certified true copy of the promissory note was never a priority. You come into the office, and of all the things that you needed to do, getting that document stamped, certified true copy of a lost note, and then getting it back in the mail to the attorney was just, like I said, just wasn't a priority. If you had 10 fires on your desk, that wasn't one of the first 10. And so the foreclosing law firms throughout the state used to start sending out incentives. Hey, get it back to us, we'll send you $25. Hey, get it back to us, we'll send you $50. And so, no, we would do it for free. I like the $75, but we would do it for free. You feel an obligation to the lender that you did the business for to begin with. You have a duty to them to see that transaction to the end.
But I got a question for you.
Yes, ma'am.
I know, and I'm probably jumping ahead, but like for a succession,
Mhm.
or an original will.
Yes.
If there was one and it was lost, they have to do an affidavit to prove that there was one. Is this the same way? They have to do an affidavit that there was an original?
No, when it comes to testaments, and we'll talk about that in testaments, when it comes to testaments, there is a means by affidavit that you can prove a photocopy of the testament was in fact the last will and testament. I don't think that a certified lost original statement by a notary in itself is sufficient. I want to say that statutorily, you're going to have to get a witness and the notary or both witnesses to corroborate. It requires more than one person to say a copy of a will is still valid. And don't hold me to that. We'll talk about that when we get to testaments, but I'm pretty sure it takes more than just one person to say a lost will is valid. Okay? All right. Registration and notarization go hand in hand. Notaries are required to record their acts, and recorders are required to receive all notarial acts. The close relationship established in Louisiana's infancy ultimately provided one basis for the judicial adoption of Louisiana's Public Records Doctrine. Notarial instruments recorded or registered with the clerk of court include the following: acts involving movable and immovable property, conveyances, sales, exchanges, and donations, mortgages, acts of cancellations of mortgages, business organization charters, bonds, oath of office. Oath of office is what they're going to be. That's what you're going to, when you pass the notary exam, you're going to be sworn in your capacity as a notary. You're going to execute an oath of office, and that oath of office gets recorded. The bonds that they're talking about could very well be, an example would be a notarial bond. A notarial bond that you might be required to meet the minimum standards to be an active participating notary in the state of Louisiana. Business organization charters. As a notary, in my capacity as a notary, I don't deal with businesses very much anymore because the Secretary of State's website is incredibly user-friendly, ridiculously user-friendly. Most people just go online and set up their corporations now. I don't think there's a lot of business work for notaries. Whereas when we did do notary work for businesses, we formed their LLCs and we formed their articles of corporation. We would have an obligation in our capacity as a notary to take those charters down to the clerk of court and file them. It doesn't get done very much anymore because the consumer who goes online and clicks the buttons and picks the name and puts in their credit card and gets their charter in the mail, they have no idea that there's a statutory obligation to record it. So there's not many charters recorded anymore, but at one time, charters were very routinely recorded. And a charter to your business is just who the principals of the business are, what the nature of the business is, when the meetings of the business is going to be. It's not a particularly complicated document, but there is an obligation to be recorded. Mortgages, conveyances, sales, exchanges, donations, acts involving movable and immovable property. Not all acts involving movable property need to be recorded. Bills of sale for the sale of your car, a bill of sale for the sale of your boat, those things don't get recorded, but a bill of sale for a mobile home that's going to subsequently be attached to a piece of movable property is an example of where you might get a movable record in the public records. If I have a business, like a dentist office, for example, and I've got a lot of movable property that's going to be incorporated into my office, attached to the wall, like those X-ray machines they pull out the cabinets and put on you, that kind of stuff, the bank may want to file an affidavit that says, despite the fact they've been recorded in the public records, I have reserved the right to go recover that collateral if the dentist defaults on the loan. So those items in the dentist's office may be movable by destination. They file an affidavit saying despite their appearance of being attached, they're still movable and therefore I want to be able to recover them. So that's an example of how a movable would be recorded, but I don't want you to look at that statement and think it's a blanket statement that all movables get recorded. Okay? State agencies. A successful notary will have a basic understanding of the state bureaucracy, because it is the bureaucracy that creates much of the need for the paperwork that requires a notary's imprimatur. What's more, the bureaucracy is the permanent repository for just about every document on which the notary will fix his seal. The public often decries the bureaucracy and the red tape on which it seems to thrive, but protecting the interests of an individual is at the heart of it all. Those interests bring people to the notary's desk, so one should be cautious in thinking of the bureaucracy as an unnecessary inconvenience. What they're telling you here is that the best notary is a notary where things. The best notary is a notary who knows where things are and where things need to come from and where things need to go. So you're familiar with the clerk of court and the secretary of state and what functions they serve and what they do will allow you to be a better notary for your client. So they're telling you here, the secretary of state, on top of page 41, he, Mr. Shedler, who's a Slidell guy. Mr. Shedler is a retired banker from Slidell, and he's our Secretary of State. It says the Secretary of State is responsible for qualifying certain candidates for elected office in the state. He oversees elections and tabulates and verifies election results. Livette, you work for Mr. Shedler in that capacity, don't you? Don't you work the voting booth?
Yes, I do.
So you work for Mr. Shedler when you do that.
Yes, I do.
All right. Official Registry of Public Officials. The Secretary of State maintains the official registry of elected and appointed public officials in the state and receives and files the oath of office taken by those officials. Your oath of office is included in that. It says this office also issues apostilles, which are certificates attached to notarial acts that are intended for foreign registry. The apostille attests to the authenticity of the signature and the bona fide the notary passing the act. A good friend of mine a few years ago adopted a child from Panama. Everything that he had to be notarized, and talking tons and tons and tons of documents. So these documents get sent to Panama, and they got Ray Brenson's signature on them as the notary. The Panamanian government has no earthly idea if I'm a valid notary or not. They have no earthly idea if I'm not just his neighbor who signed my name and went to Home Depot and put a little stamp on it. So an apostille, if I'm pronouncing it properly, and I don't know that I am, an apostille is something the Secretary of State puts on a document that indicates that the notary who passed the act is in fact legit, so that the burden's not on the Panamanian Adoption Agency or the Panamanian government to come find out if I'm legitimate or not. They can rely upon the Secretary of State's representation that I am. Okay? The Commercial Division. The Commercial Division of the Secretary of State receives, processes, and accepts or rejects the initial paperwork required to form corporations, LLCs, and other business entities. It is the place to get a birth certificate for a juridical person. The Secretary of State will not sign the certificate of organization of the entity unless the notary's work is correct. The Commercial Division also maintains a database of trade names, trademarks, and service marks, and relies on an affidavit signed by a notary to enter the information in that database. That trade name, trademark, service mark work has also been taken away from notaries. Mr. Shedler's got to click the box, pay a fee form for that, so you don't do much of that anymore either. Everybody know what a trade name is and a trademark is? Okay. A service mark is very similar to those items. A service mark is a mark related to a service industry. Trademarks are related to products. But it's all something that is an effort to protect your brand, your logo, that kind of a thing. And those documents all at one time had to be notarized. That's not the case anymore. The Secretary of State maintains the archives of official state papers, such as the acts of the legislature, executive orders of the governor, and other papers of the state. The Secretary of State is also who's kind of the head of this program. We talk about Dr. Matthews, who's at LSU, who creates the test and who grades the test, but ultimately he reports to the Secretary of State. They maintain the notary database. They're the ones who will let you know if you're a notary or not. The Secretary of State also has a will registry, which is something that's kind of interesting. They don't actually have the wills. What you do is you pay the Secretary of State $10, and he will put on his database where your will is. Because obviously, if you pass away, who's going to know where your will is? So if you don't necessarily know, if you're the parent, if you're the child of a deceased parent, they've passed away, and you don't know who their attorney was or where their will might be, you know what you want to do before you give up? You go to the Secretary of State website and see if they registered where the will is on the will database. You were shaking your head yes. Y'all do that kind of work for Mr. Seamus?
No, I learned that in notaries, like when I was, not notary, when I was going to school to become paralegal.
I gotcha. Yeah, so the notary. Now, I don't know a lot of people that use it. It's I've had some
How old
call.
is that? How old is the registry?
Oh,
It's been around a long, long
oh yeah,
time?
it's been around a long, long time.
Like 78?
I can't say 78, but it's been around a while.
Behave, Patty.
But the problem is that it's not always very accurate, you know, because people change their wills pretty regularly and they don't necessarily think, oh, I need to send the Secretary of State $10 more and update this information. So the problem with the information is that it's not always very accurate, but it is there and it is a place you would check before you would give up.
Not a lot of people know about it.
No, not a lot of people know about it. I was telling Cynthia Cotton that you deal with, she works for the Secretary of State, is that
Yes.
correct? So what is the Secretary of State's role as it pertains to notaries?
Well, they are the agency that manages and does the test. Well, LSU actually performs the test for you. Well, no, y'all perform the test, but they're the ones that,
Administer it.
they administer the test. But the Secretary of State's office is who does your application, does the entire process, and who tells you whether or not you pass the test. And then his office, the governor actually signs your certificate. He's the one who grants you your commission. But it's based on you're passing the test, and then he passes all that up to the governor, and the governor says, okay, good enough. So the Secretary of State is very involved in the notary program.
All right, so we also have the Department of Public Safety in the bottom of page 41. This agency, which is used, files affidavits from everywhere about everything. Under its umbrella exists the Office of Motor Vehicles, the Office of the State Fire Marshal, the State Police, and other commissions. Let's go ahead and skip over to page 42. Office of Motor Vehicles. How many of you knew before you read this it was the OMV and not the DMV? No? You knew it? Right. I still say the DMV, but it's technically the OMV.
Yeah.
Yeah, so it's technically the OMV. And there is a tremendous amount. We got a whole chapter dedicated to automobile transfers and bills of sale and odometer statements and things of that nature. I'm not sure what chapter it is, but it's in here. But there's a tremendous amount of notarial work done in the automobile industry. I know that first night that we met, we were making some introductions. I heard 2 or 3 people talk about doing notary work in the automobile industry as a result. There's lots and lots of work like that. The Louisiana State Police, in the middle of page 42, it says the Office of Louisiana State Police administers numbers of programs requiring affidavits accompanying numerous forms. A friend of mine just recently contemplated opening up a driving academy. You know how your kids got to go through a driving academy before they can get their driver's license? And that's regulated by the Louisiana State Police. And there's got to be 40 forms that have got to be notarized in any application to become a driving school with the Louisiana State Police. I'm exaggerating to make a point, but there's a lot of forms. All right, so death of the Department of Health and Hospitals, the Vital Records Registry. This is where you're going to get death certificates and birth certificates. In the Department of Social Services, Support Enforcement Services, they file lots and lots of paperwork regarding child support and things of that nature. And I don't know how much of that work you would do directly for them, but you'll do an awful lot of work for the fathers who've got to sign affidavits saying that they've made payments and things of that nature. So that's where some of that work is coming from. And that's chapter 6. You want to do the quiz?
It's on the board.
Number 1, interested third persons rely on what is located in the public records to protect them against unrecorded interests.
True.
No.
That's why it's so tricky. Interested third persons rely on what is recorded in the public records. That whole chapter was about how we can rely upon what's not there. I said you don't want to lose sight of the fact that obviously what's in the public records counts, but what's not in the public records, okay, so I can see why that answer is false, but I can also see why it's incredibly tricky. The second one is the effect of recordation takes place as soon as that document is deposited in the records department of the parish in which the property is located and stamped by the recorder. True, I think that's true as well. Yep. What's the next one? With regard to recordation of conveyance and mortgage documents, the clerk of court's office is located in the Circuit Court, City Court, District Court, B and C Court of each parish.
District.
District,
District Court?
It's not the city court.
No, we have Slidell City Court, they don't have, now the Slidell City Court has a clerk of court, but you don't file any movable property records there. Isn't it Sherry Phillips, isn't that the name of the Slidell City Court? Does that sound familiar?
It sounds familiar.
Yeah, so
Yeah.
she's the civil court for Slidell City Court, but she's simply maintaining what's in the civil records and the criminal records of Slidell City Court. She doesn't have any public records as we know them that get recorded in the district court of that parish. Oh, so she took the answer now, so no, that was no question, the district court was the right answer. Alright, so we're back tomorrow night.
Yeah.
Back tomorrow night, and we'll start chapter 7. Chapter 7 is a big chapter, you got 2 nights
I do
allocated to
have
it.
to, I thought we'd
get into chapter 7 tonight.
I thought we would do it too.
But
So-
chapter 7, there's not nearly as many stories to tell about chapter 7. It's much more just rote information and memorization kind of stuff. But we'll do chapter 7 starting tomorrow evening. You gonna turn that off?
Now wait before anybody
You
leaves.
gonna turn that off and you're gonna get that syllabus out, right?